Welcome to your Key Discovery Point. I am Brett Burney from Next Point, joined by Doug Austin of eDiscovery Today. Doug, you covered a case this week, in fact, just yesterday as we were recording this, that shows the importance of being a team player when it comes to a full and comprehensive production in eDiscovery. This comes out of the Western District of Pennsylvania, I should say, just maybe about a month ago or so. Rig Consulting versus Rogers.
Yes, and there were a couple of interesting things about the case. The first thing that I think I noticed, of course, because we haven't really seen a lot of cases involving it so far, is the discovery request included a request for Microsoft Teams messages, which we haven't seen. We haven't seen much of that, which is surprising because there's like literally 280 million people using Teams, so there's some crazy number. So you've got to expect they would be there. But then the case really, to me, is interesting because it happens to be a trade secret misappropriation case involving former employees of the plaintiff and what have you. And this particular defendant, Rogers, he initially didn't really produce anything. Then he ultimately determined that he had some text messages, and he produced 1,045 pages, actually more than 1,200 pages when you added between the other two defendants that he had communicated with. He did not include the attachments to the text messages initially, but did ultimately do that. But the way he handled everything else was really interesting, and even the text messages were kind of a bit. I think he was a bit reluctant to produce those, but ultimately, one of the things that I think was interesting was he was, or at least his attorney was saying, he's had communications with Rig's customers and with former employees, and he's well within his right to do that. And a month later, he said, "Oh, there's no communications available." And the judge, Judge Colville, kind of saw right through that and said, basically called it inexcusable for him to come back and say there's literally no emails, no Teams messages related to Rig's customers, related to Rig's employees, and what have you, when he had 1,200 pages of text messages. And so Judge Colville essentially put him on notice that you've got one more chance and you better be producing, discovery, because if you don't, then the sanctions are going to be worse than they already are. And the sanctions so far is just limited to costs and fees for the associated with this particular motion, which he also made plaintiff's counsel, Rogers' counsel, pay 50% of. So,
ouch.
Yes. So, a couple interesting things, and it's like that. That continuing, he added paragraph there where he said, I didn't possess any information, but then he said, well, I searched and found 1,200 pages of responsive text messages. And one of the notable things is he says, his focus on the possession aspect of Rule 34 strikes the court as an attempt at clever gamesmanship.
Yeah, clever gamesmanship.
The court calling you of clever gamesmanship. So, this is a good. This is kind of almost bordering on a Judge Peck Rule 1.1. Don't piss off the judge kind of case. You can tell that the judge is starting to get a little annoyed with defendant in this one. So, it will be interesting to see what happens.
I will have to say, I found that possession argument a little interesting just because it's like, well, is that information in his possession as like on his computer? Is the data actually stored in a server, which he may or may not have access to now? It's that kind of a thing. I mean, I agree with you. I think the courts kind of saw through this, but I liken it to one of these arguments. It's like, hey, why not try it, right? I mean, in the early days of eDiscovery, we would claim that, before Rule 34 was amended, that a spreadsheet or an email wasn't a quote document, right? And so, well, it wasn't listed there. So before we included electronically stored information, so I just found that interesting that's the first thing I thought of. Is like, well, they're going to try to throw that argument out there, but the judge was not going to have anything to do with that.
That's a good way to put. Yeah, that's a good way to put it. Kind of throw it against the wall and see if it will stick.
It's a little
Yeah,
stick.
yeah. Because I mean, really, I think he's kind of saying it's not in my possession. It's in the company I work for's possession, so I can't produce it.
Yeah, yeah.
And of
Well,
course, he has
yeah, and just
access.
to underscore yeah, and just to underscore that, I mean, he appeared to have provided and produced the text messages, which, I don't know if that was screenshots that would be on his phone, or maybe he could go to his iCloud account if it was Apple or something like that. But with Teams, typically the way that we do a lot of that collection today is we do go to that server, right? Microsoft 365 and Purview, and we collect it from there. And, used to have an administrative account in order to do that. So I obviously don't know anything about this case and if that's some of the issues there. But again, just to kind of underscore maybe why they were trying to approach that, it seems like to some extent the text messages may have been easier or maybe even more difficult to produce as opposed to the Teams. But again, I just don't know the inside workings of all of this. But
Yeah,
it came down like, yeah, go ahead.
Nor do I. Nor do I. My conjecture is he couldn't make that argument with text messages because they're on his personal phone. So it's like,
Right,
he can't say I don't have possession of these, but he could say it with. We know emails. There's long existing processes
right.
producing emails. There may be not long existing processes for Teams messages, but they do exist. And the thing is he's coming back saying, "Oh, I don't have any. Not in my possession."
Right,
And
right.
that just the judge just saw right through that.
Well, and throughout this, again, this is sort of a theme that keeps coming up with a lot of these cases we discussed, Doug, that the court was just not happy that the sides, first of all, were having to go through all these discovery, shenanigans and sanctions and back and forth. And I think, at the very end here, you obviously link to the Minerva 26 case from Kelly Trigger's company that the court was like, well, go back. I hope that the parties are going to talk about the actual search terms that they would have looked for. And then come back before, but and then come back after that. But who knows? It doesn't look like there's a good history here, and the court, the judge may have to come back and give another ruling, which I'm sure is not going to make them happy.
Sure. Well, and IP cases tend to be the most contentious because,
Yes.
there's the whole, aspect of, oh, the employees left and they took IP with them. And then that, sometimes those defendants can be a bit resistant to the discovery because they don't want to turn over things. So, not that
Right.
we know that that's necessarily the case here, but there's always the plaintiff side saying, I know you took something, and the defendant saying, no, I didn't, but
Right.
so it's that sort of thing. These are definitely among the more contentious cases that I think we both probably see.
Well, there was obviously a lot of meet and confers happening in this, or there was supposed to be. And if you wanted a little more information about how to conduct a winning meet and confer process, at Next Point, we have a white paper about that called Winning the Meet and Confer Process. I'll make sure that we have a link in the show notes. Your key discovery point today, Doug, be a team player when it comes to production. I know that there's a lot of contentiousness that happens in there, but it's just not probably going to go over very well with the court.
Yes, I would say be a teams player in this case. But
Good.
you see what I did there. So
I did. Thanks for joining us, Doug. We'll talk with you next time.
thanks, Brett. Thanks, everybody.